Okay, guys, thank you, Omer, for the introduction, and we have some work to do. It's a pleasure to chair this session, and I will introduce our panelists shortly, but I do want to say a few words about the topic of this session, which is about adequacy, just to make sure that we are all on the same page. As the EU was debating what has become later on the Data Protection Directive in the early 90s, it realized that it will be wonderful if the EU will have its own regulation of personal data, but this entire regulation will be meaningless if European data can be collected and processed outside of the EU. So they sought a solution for this problem. This problem, with the advance of the internet, of course, became more acute. The solution that the EU has found, as Commissioner Jourova has mentioned, was that European law should follow European data. And they did so, the EU did so, by saying two things. First, European data should not be taken outside of the EU, but for a few derogations, a few options. One of them, for example, is consent, an explicit, unambiguous consent of the data subject, the European data subject, that his or her data will be transferred outside. It's doable, but of course it's expensive, cumbersome, and difficult to do. There are other options, such as the binding corporate rules and standard contracts, etc. But the main road for transferring European data, personal data, outside the EU is what we call the adequacy. A third country, meaning a non-EU country, like Israel, in our case, can approach the EU and ask, please check, please evaluate, and say that we have an adequate data protection legal regime. If so, the transfer of European personal data to the third country is allowed. Israel has approached, indeed, the Israeli government has approached the EU in 2007. It took a while, and in 2009, the Article 29 Working Party has recommended that Israel is recognized as having an adequate data protection legal regime, and in 2011, in January 2011, the EU Commission has affirmed this decision. In other words, Israel has, like a few, not too many, other countries, has this status of being adequate for this purpose. This adequacy status has huge financial implications. It streamlines the transfer of personal data from the EU to Israel. This is very good for Israeli businesses who do business with European consumers, customers, or with Israeli or multinational companies that obviously have data about their employees, including in the EU. Quite a few things have changed since 2011. First, the GDPR, which will enter into force next year and has many elements which Israeli law at this point does not have. That is one thing. Another new development is the decision of the European Court of Justice in October 2015 in the Schrems case. Max Schrems will be here in this conference in a few days later on this week. Don't know. Are you here? No. Yeah.
We know him.
Not yet. That decision dealt with the transfer of European data to the US following Edward Snowden's, he's not here, following Snowden's, as far as we know, yes, maybe you can never know, following Snowden's revelations about the NSA. This means that everything is up for grabs, and the first question, which I will shortly direct to our panelists, especially the European and the Israeli officials, is what about the Israeli adequacy status? Is it being reevaluated? So, to discuss the issue of adequacy, and specifically that of the Israeli status as having an adequate legal protection. We have here 3 representatives: European business, multinational business, and the Israeli government. So each of our speakers will have about 10 minutes, and then we will have some discussion among ourselves and with the audience. Our first speaker, I will present all of you, if that's okay, to save time, is Bruno Gencarelli. Bruno heads the International Data Flows and Protection Unit at the European Commission. He was heavily involved in the legislative process of the GDPR and was one of the lead negotiators of the new European American Privacy Shield, which followed the Schrems case, which invalidated the previous arrangement. Orly Friedman-Marton serves as the head of legal and corporate affairs at Microsoft Israel, and Dr. Roy Scheindorf is the Deputy Attorney General for International Law at the Israeli Ministry of Justice. Just as a matter of disclosure, when the EU conducted its first evaluation of Israel's adequacy some 10 years ago, I was subcontractor for the EU Commission, but that was 10 years ago, and everything, or a lot, has changed since. So, Bruno, do you want to talk from here?
Yes.
Okay,
no, I'm fine here. I'm fine.
That's fine. And
yes.
Just before you begin, please, what is the status of Israel's adequacy? Is it being reevaluated, or what's going on?
This is working. I'll answer to the question. Thank you very much. I'm delighted. It's a real pleasure to be here. And I will, to answer your question, I will briefly touch upon 3 questions or 3 issues, 3 aspects of the question we are discussing on this panel. So first, is that better? Yes. First, the status of the adequacy decision with Israel, its importance, its benefits. Second, the ongoing work which is currently being done to ensure the continuity of the adequacy decision, its sustainability. And third, I would say, apart and beyond the adequacy decision, because the title of this panel plays a bit with both the GDPR and adequacy, the impact of the GDPR on foreign companies, foreign controllers, including Israelis, of course, and its relevance for the EU-Israel dialogue on data protection and privacy. So you have already dealt with my first part, but I cannot stress enough the importance of the 2011 Israel adequacy decision to echo the biblical image that was referred to by Jules Polanowski this morning. We have a common tent, and in a place which is now a bit more comfortable than the Sinai at that time, but we have a common data protection and privacy tent, and indeed an adequacy decision. Basically what it means, it's free flow of data between the EU and the third country in question, in this case Israel, and it is, and an adequacy decision does something which is kind of powerful in the sense that it approximates the third country system and recognize and has as an effect that for that purpose, for the purpose of data protection and data flows, the third country is considered as a member of the EU. With an adequacy decision, data flows between, let's say, Italy and France, and data flows between Italy and Israel are treated the same, with no need for a further authorization or for a further legal basis for transfer. So that's something quite rare in EU law, that we extend the benefit, and of course with enormous benefits in terms of access to the internal market, extend the benefit to a third country which is not subject to the same rules. That's why the adequacy test is a quite strict test, which requires, and I will come back to that, a comparable level of protection, which has been clarified by the Court of Justice in the Schrems case you've already mentioned, as a level of protection which is essentially equivalent to the one ensured in the EU. Let me stress also that if the adequacy decision was with Israel, which was adopted in 2011, was important, it is even more important today, because compared to 2011, our trade, but not only our trade, our commercial flows, but also our law enforcement cooperation between our public authority relies even more on personal data exchanges. So the importance, and that's why the reason why, amongst others, the Commissioner is here and we are all here, the importance of the adequacy decision has to be stressed. Then the question is, you've mentioned the adoption of the GDPR. What happens with the GDPR to an adequacy decision that was adopted under the current rule, therefore under the rules of the Directive 1995. The GDPR, in its Article 45, paragraph 9, provides for the continuity in principle of adequacy decision adopted under the Directive 95. There's no, and that has been part of the debate in Europe, there's no automatic sunset clause. There is a choice of legal certainty and therefore legal continuity and therefore legal certainty, and there is no need to systematically review or readopt adequacy decisions that were adopted under the current rules. That said, and there's always a but also in nice stories, there are an adequacy, and that was true actually in 1995, under the 1995 directive, and it's even more true under the regulation, is adopted at a certain point of time. It's a finding made at a certain point of time that a certain system, in this case the Israeli, offers a comparable level of protection. As everything in life and in this world, privacy laws, both in the EU and in the foreign country, might evolve, and they might be developed that might affect the finding that was made at a certain point in time. And that's why adequacy decisions are considered as a living document that needs to be closely monitored. And that actually was one of the main lessons to be drawn from the Schrems judgment. The Schrems judgment that, as has been recalled, has been adopted, I would say, in the wave of the Snowden revelation, and has found that the EU-US safe harbor, which was the arrangement which was previously in place with the US, was invalid. What is interesting about the judgment is that the judgment makes findings that concern in general the adequacy regime and that go beyond the question of the EU-US, and those findings on the adequacy regime, it's even more important, have been in the meantime codified by the legislator, because you find those important points of the Schrems judgment in the GDPR, in particular in Article 45, which is the article which deals with adequacy. So very quickly, what are those 2 or 3 lessons from the Schrems judgment? First, the first one, I've already mentioned it, that an adequacy decision has to be closely monitored, and the Commission, and it was a tough lesson for us, cannot do what it was perceived as doing in the past: adopt an adequacy decision, put it in the drawer, wait for the dust to gather on the adequacy decision, and then wake up when it's too late, like with the safe harbor. So that's we have therefore this obligation to periodically assess and review whether the finding which was made is still valid. A second very important lesson to be drawn from the Schrems judgment is the test of adequacy. The court has clarified that adequacy is about finding, as I already said, a level of protection which is essentially equivalent to the one in the EU. Often, commentator stops there. The court also says something else, that essentially equivalence doesn't mean identical. We are not looking for a carbon copy, a photocopy of EU law around the world. We are not looking for a point-to-point symmetry. What is important is that the foreign system in question, the Israeli system, as a whole, with its differences that are based on different legal traditions, as a whole delivers a level of protection which is essentially equivalent. Of course, this requires a number of core principles to be there in terms of enforceable rights, in terms of independent supervision, etc. But there is that very important finding of the court, both in terms of the test and of what that test means. And that's the third lesson, and I know I'm already probably I've used all of my time, but the third lesson is, that's probably the most complex one, that essential level of equivalence has to be found on the basis of a comprehensive assessment of the foreign system, which doesn't look only at the privacy law in itself, in the books and in practice, but also at issues that are a bit more, and we had the pleasure to negotiate those issues with the US, which concerns the rules, safeguards that apply when public authorities seek for very legitimate purpose of law enforcement, national security, to access the data in question, the personal data, because the Commissioner referred to the continuity of protection. That also applies in this case. Data can be, and it's more and more the case in the digital economy, can be first collected in Europe for commercial purposes, transferred to Israel for commercial purpose, and then again for very legitimate purpose can be then accessed in Israel, in the US, in New Zealand, in Canada by public authority for law enforcement, national security, and other public interest purposes. What happens in that case? What are the safeguards? What are the limitations? What are the judicial redress avenue? All of these things, which make our work more interesting but also more complex, have now to be assessed when considering an adequacy. So on that basis, and that's one of the reasons we are here in Israel, we not only recognize the importance of the existing adequacy decision, including the one with Israel, but one certainly to ensure, to strengthen them so that they can continue to deliver the benefits. But for that, we have to do this exercise, see whether the adequacy decision that was adopted in 2011 complies, fulfill the test by the court. And that's why, and I'm very pleased to do, of that, we have ongoing dialogue with the Israeli authorities to update, in a certain sense, our finding. And that's again done, please, that's a core message, to ensure the continuity of the decision. This is
So just to clarify, when you say to update, does that mean that the EU will reevaluate Israel's adequacy status?
It's not about reevaluating. It's part of our ongoing monitoring, which, by the way, was already foreseen by the 2011 adequacy decision. Is that if we have to be assured that what we found in 2011 is correct, including in light of the new elements that have been provided by the court. If the answer is yes, there will be nothing to do with the adequacy decision. If we have a further question, etc., it is, I would say, very good and in the benefit of the two sides that this dialogue exists. And the third element, and I will be even quicker on that one, as I said, apart and beyond the adequacy decision, a key, and that has already been mentioned in the previous panel, a key aspect of the new regulation is this increased geographical scope. And the fact that the GDPR, as it has been mentioned, can also apply to companies established abroad if they process data in the context of offering goods and services to EU users and EU users, EU consumers. And that, I would say, opens a new chapter for the EU-Israel relation and dialogue in the area of privacy and data protection. Because we see our relation with adequate country as a two-way dialogue, which is particularly important in a moment like this, where in the EU we are in the process of the implementation of new rules, and in Israel, as was already mentioned, that May of next year will be a big data protection month. You are in the process of implementing new rules. There are a lot of interesting commonalities between these new rules. I'm thinking about the risk-based approach and how we are, with our data protection authorities, trying to define the level of risk. You are going through the same exercise. So there is, I think, room for both, and we are very available to do that, providing the necessary clarification on the new EU data protection rules to stakeholders here, which might be caught by the new scope. But there's also, I would say, a new chapter in terms of exploring ways to increase the convergence between our two systems, exchange best practice, address together some common issues. So a lot of more work to be done. Thank you very much for your attention. And we are eager, of course, to engage on all of these aspects with our Israeli interlocutors.
Thank you. Very diplomatic, I must say, the emphasis of the commonalities. Oli, Microsoft, how do multinationals cope with all of this?
Okay, so I'll also do a few opening remarks and said a few comments. The first one would be, I think, is our discussion here is focused on adequacy, or that's its name at least, and I think we could go a little bit further than that, or be a little bit more ambitious than that. I think we should talk about harmonization. I think that looking at GDPR, that's exactly what it did for the EU, and actually facilitated for the EU and beneficiated the EU as a single market. I think that beyond that, it is clear that the GDPR is setting a standard on a global level. There are a lot of countries around the world that are at this stage worried the same about privacy and about security, and they are weighing and considering various legislation pieces of work. And a lot of them, or at least for a lot of them, and for a lot of regions around the world, Europe is kind of a North Star for these issues. So there is an expectation for the GDPR to be addressed in that manner in many places. And I think it's important to consider that even if GDPR is not ideal, it would be, at least in various places, a de facto standard. We should give it the credit of being a result of long or several years of consultation by the EU leading, I would say, regulators in these fields. Looking at our current legislation locally, I would say Commissioner Genova addressed the EU Directive from '95. Our relevant law in this field is dated back to 1981. The internet was not available in 1981, and data was mainly considered to be physical data. We are living in a totally different world today, and obviously there has been patchworks for the Israeli legislation throughout the years.
Not that many.
But even, first of all, totally agree, but even in the 2017 now regulations that are dealing with data security, and we still have a long way to go as far as regulation. So I would think we definitely should consider that harmonization that goes beyond adequacy, just because it will automatically achieve adequacy. That's the first thing. Second, from a business perspective, first of all, EU was first. It set the standard. It's bigger. From an economic perspective, it has a lot of impact on Israeli businesses. And if we look at our startup nation, at our SMEs, at our SMBs, at their innovation level, at their need to, or at their practices of working way beyond and above the Israeli market, there are a lot of benefits that could arise from that. Obviously, these are not limited only to businesses. They are also related to collaborations from the enforcement side, as Oli mentioned.
Yeah, but how does Microsoft, as a multinational company, which works also in the US, which is not exactly adequate, how does it deal in such a fractured kind of global environment from a data protection?
I will answer that immediately. Sure. I just want to say a second comment beyond harmonization that is more pragmatic or practical. I'd argue that the GDPR is pragmatic by giving various options of being adequate. I think I heard Commissioner Jourova say in the morning that, and based on the periodic review of adequacy, that we're expected to be there somewhere along 2020. But I do understand that from a practical perspective, not all countries would harmonize themselves with GDPR, and even Bruno said, you know, there's no idea for copy-paste across the board. It is a complex piece of legislation, and so it won't be completely or automatically adopted everywhere. But I would say from a pragmatic perspective, I would say two comments. First, I would say that EU, while reviewing adequacy, should not request or expect other countries to stand up to things that are not necessarily met across Europe. That would be my first comment. And the second one would be that there are alternatives within the GDPR for adequacy for a country. So even if Israel is not found adequate, there is potential of assuring adequacy of certain verticals, for example, ones that are more regulated heavily in this field, or partial adequacy, as it's called, like in other places, through agreements, for example, like the U.S. Privacy Shield or others. My third comment, and that would be, just before answering your question, would be one sentence. I'd argue that our conversation here is so much wider than what I usually hear. A lot of the times it's referenced as an IT organizations or an ICT issue. I would argue that in this time frame and in this era that we live in today, which is at the outset of the fourth industrial revolution, I claim that there are new business models and that each and every company is actually turning to be a data company, and hence the relevance or the importance of this conversation goes way above and beyond. And last, I would address your question as a multinational. So as a multinational, Microsoft has already committed publicly that it will comply with GDPR across its online services across the board. This actually goes hand in hand with our long-term heavy and very wide-scale commitments towards compliance, privacy, security, complying with worldwide leading standards in these fields, and that's our commitment on that level. I'd say that beyond that, we're putting in place a huge amount of technological tools that enable and assist our customers as for their part of their responsibility, not just leaning on our cloud to help them to comply, but rather help them to comply in their part of the responsibility as either processors or controllers of data through technological tools that enable them to audit and report and achieve consent and analyze threats or other issues that are part of the GDPR.
Thank you. I must intervene and say that I think this, from a political science point of view, this is a fascinating process in which the EU, without requiring other countries to adopt a certain law, has this global impact with so many countries and companies, multinationals, adopting European or European-style law. And I believe, by the way, that the United Arab Emirates has copy-pasted the directive as is at some point.
We just heard the UK post-Brexit actually a declaration 2 or 3 days ago.
They're still in the EU for the time being. So yeah, thank you, Oli.
Thank you.
And now to the perspective from Jerusalem. Roy, bevakasha, please.
Okay, well, I've prepared actually written comments, but of course
even more diplomatic.
we can. But of course, I will be delighted then to engage in a conversation immediately afterwards. I would like to begin by expressing how delighted I am for having the opportunity to be here today and to take part in this extremely important panel alongside such distinguished speakers. As Deputy Attorney General for International Law in the Ministry of Justice, my work is usually focused on questions such as treaty interpretation and implementation, international humanitarian law, and the like. The question being raised in today's panel has broad implications for domestic and international trade, but it is essentially a question of domestic law. What does Israeli law have to say about privacy protection of personal data? Privacy law is not my field of expertise, and so I approach this from an international law perspective. Clearly, concern for privacy and the protection of personal data has been growing over the years. As the internet became ubiquitous and as information technology startups became giants of the global economy, those involved in this field have asked important questions about the protection of personal data in the digital age. In a post-Snowden world, these concerns have increased substantially. Israel just as every other country around the world, and especially modern democracies that are also technologically advanced, seeks to continue to derive benefits from these advances and from the free flow of information, while not infringing on individuals' rights to privacy. Each country that grapples with this question does so from a different perspective, based on its unique circumstances and a myriad of other factors, including social norms, values, national institutions, and each country's unique legal system. For example, the EU comes to this question from the perspective of human rights and the right to privacy, while the United States has a different approach entrenched in the right to property. In Israel, our system is built on the foundation of being a democratic and Jewish state. The right to privacy is a human right enshrined in the basic law, human honor and dignity. Or
Human dignity.
Human dignity, yeah. As we will shortly see. As to our Jewish heritage, we have legal texts going back 2,000 years that deal with privacy on a very practical realm. So, for example, the Mishnah says, a person should not open up windows so that they face a joint courtyard. In a courtyard which he shares with others, a man should not open a door opposite someone else's door, nor a window opposite someone else's window. We see here a deep concern for privacy with actual windows years before we had Microsoft Windows. So I would like us to travel from that joint courtyard, which was probably right around this area 2,000 years ago, to our globalized world, in which international data flow is a major part of how the world works, how business is done. In current times, we need to figure out how we can work together and how we can allow this flow to continue while providing the protection we each deem appropriate for such sensitive data. The GDPR, and before that, the EU Data Protection Directive of 1995, has a unique place in the global ecosystem. At its core, it represents the EU's expression of its own privacy values, the standard according to which it protects the personal data of data subjects based in the EU. Within this tension between domestic privacy protection and allowing international data flows, there emerged the idea of an adequacy determination, by which the EU seeks to ensure some measure of privacy protection for its citizens in respect of data flowing outside of the EU. For Israel, and I imagine the other countries that have been determined adequate, this is at the same time an opportunity and a challenge. It is a challenge because it means, in essence, that we have to make a choice as to whether we want to adhere to a set of legal standards imposed, so to speak, by a foreign jurisdiction. At the same time, it is clearly an opportunity because the EU's privacy standards are widely recognized as being thorough and of high caliber, and so if we can meet that standard, that's a benefit for our citizens as well. Not to mention the trade opportunities with the EU. So the question before us today is to what extent Israel adheres to these standards. I'm not going to attempt to answer this directly. I leave that task to our privacy experts. But I am going to show, I hope, that our current privacy ecosystem is excellent and that our privacy protection regime is consistent with that existing in other modern democracies. To do so, I will first give a little background on the right of privacy in Israel. I will then provide a few examples of recent developments in this field that indicate the direction in which Israel is moving to protect privacy and show Israel's advanced approach to privacy protection. To begin, some background. The issue of privacy protection and personal data protection is a central and essential topic in the Israeli legal system. The right to privacy is embedded in Israel's constitutional law under the basic law, human dignity and liberty. This constitutional right has been broadly interpreted by the Supreme Court to include various components of privacy protection. In addition to being a constitutional right with extensive protection, the right to privacy also appears in a number of legislative texts, primarily the Privacy Protection Act of 1981. This law was considered both modern and innovative at the time of its enactment in 1981, and to this day remains relevant. This is because the Act addresses a wide variety of aspects of the right to privacy. Taken together, the Basic Law and the Privacy Protection Act create a strong and secure foundation for privacy protection in Israel. Israel faces similar privacy protection challenges to many other countries around the world, such as the challenge to balance between privacy and national security. This too requires a delicate approach, as the state must balance its needs or even duty to protect its citizens and keep them safe, and the right to privacy. Israel has a variety of tools which it uses to manage these challenges and to cope with the new realities it faces in the fields of technology and security. Israel's legal system strives to protect the privacy of its citizens to the fullest extent through a mix of robust legislation and proactive enforcement. The EU, through the GDPR, also has its own set of tools to deal with similar privacy and data protection challenges. As we all know, the GDPR is the culmination of the European Union's intense internal work to further advance data protection. This legislation is both impressive and progressive, as it strives to update the 1995 Data Protection Directive and copes with some of the new challenges that the world is facing. When examining the implementation of the principles enshrined in the GDPR in any country, one must look at that country's legal system as a whole. In Israel, it is necessary to look beyond the legislation itself, as this would only show a partial picture. Our legal system is based on common law, therefore legislation is not the only binding factor which creates law. Supreme Court case law plays a central role as well, as it develops and interprets legislation and sets binding legal precedents. Additionally, there are many administrative rules and regulations that hold considerable weight in our system. Moreover, when speaking about the implementation of the GDPR in Israel, there are many factors that need to be taken under consideration when making these decisions. But when focusing on the fundamental values embodied in the GDPR, it is evident that Israel holds a similar set of values. I would now like to present two important developments in Israel which illustrate how Israel is approaching privacy. I believe these examples demonstrate Israel's cutting-edge approach to privacy regulation. The first example I would like to discuss is the privacy protection data security regulations, which I know Alon discussed earlier. So I will just say generally, the regulations which will come into effect in May 2018 constitute a major development in Israel's data protection policy. They will establish organizational mechanisms aimed at making data protection a part of the management routine of all organizations processing information in Israel, both in the private and the public sectors. These regulations are expected to substantially improve the level of data protection in Israel. They include concrete and detailed provisions which closely guide organizations and clearly instruct them on how to act in specific circumstances. The way in which the regulations will be implemented is by classifying databases according to the level of risk they create when processing information. The level of risk is determined by various factors such as data sensitivity, the number of data subjects, and the number of holders who have access to the data. There are different sets of obligations imposed on each holder of personal data according to the level of risk they were assigned. What we see here then is a modular approach that takes into account market realities, but at the same time sets a solid baseline standard. There is a careful mix of principles-based regulation and prescriptive rules. The regulations are truly innovative, and when they enter into force, they will create a complete reform in our data protection policies. My second example is the implementation of the principle of privacy by design in the development of legislation. The Ministry of Justice and the Israeli DPO, ELITA, work closely with various government offices, providing them with guidance and helping shape new legislation and governmental projects from their earlier stages. This guidance is meant to ensure that considerations of privacy protection with all of its components are taken into account before passing legislation or while designing new projects. This design is extremely effective as it ensures before the fact that when a law is implemented in the future, privacy risks will be minimized. There are many examples that can properly illustrate the effects of the privacy by design policy, but I would like to focus on one in particular, the credit data law.
Oui.
This law sets forth a new system allowing the collection and sharing of credit data, but in a manner that minimizes the risk of infringement upon the right to privacy. This law is based on the recommendations of a government committee established with the sole purpose of examining the issue of sharing credit data. This committee helped shape the law from the very beginning and allowed for more extensive privacy protection in the field of credit data than ever before in Israel. The new legal arrangement, which is based on the conclusions of the committee, expands the scope of information that can be collected from a customer by default. At the same time, it includes extensive privacy protection measures. The law delicately balances between public goals and potential violations of the right to privacy while minimizing violations. Generally speaking, I understand that our privacy experts are still in the process of studying the GDPR in depth. I know that Israel is optimistic about maintaining its adequacy status, which was originally granted in 2011. I believe that given the depth of trade relations between the EU and Israel, this is the EU's interest as well. Indeed, the success of the GDPR will depend in large part on its wide-scale adoption by as many countries as possible through an adequacy determination or equivalent regime such as the US-EU Privacy Shield to jurisdictions across the globe. Since, as I noted, privacy protection is primarily a question of domestic law, I've been working in close coordination with my colleagues, most notably Mr. Alon Bachar, head of ELITA, Mr. Raz Nizri, the Deputy Attorney General for Public and Constitutional Law, and Mr. Eyal Zandberg, Senior Director of Privacy and Personal Data Protection, and I would like to thank them for the fruitful collaboration in the process in general and in preparing this presentation today. Finally, we were invited by the EU to provide an update regarding significant changes and developments in the privacy and personal data protection regime in Israel since the adequacy decision of the Commission in 2011, and we have just submitted to our counterparts in the EU an initial report which is quite comprehensive. We are proud of our accomplishments in the development of privacy law, and we look forward to the constructive dialogue with the EU officials. We're committed to working with the EU and other countries around the globe to continuously improve the way we protect our citizens' privacy in a manner that is realistic, adaptive to technological change, and rooted in our shared commitment to human rights. Thank you very much.
Thank you, Rui. I hate to break the party, but I'm afraid I have to. It's beautiful, the optimism and dialogue and working together, but let me translate a few of the things that I heard. When the EU invites Israel to comment, it means you'd better do that, okay? Otherwise, the adequacy is in danger. When Israel says that we have been working a lot, well, I reread the decisions of the EU Commission, and it in its adequacy decision about Israel, and it heavily relies on the Shofman report. Joshua Shofman was Deputy Attorney General more than a decade ago, and in January 2007, Shofman submitted a report with many recommendations. The EU said at the time, we give you Israel adequacy based in part on the execution of the recommendations of the Shofman Committee. How many of the recommendations have been implemented? Nothing. Okay? The last time the Israeli data protection law was amended was in 2007, 10 years ago. So the recent data security regulations is definitely a very good advancement. I believe it should have been in primary legislation rather than regulation, but okay, and the regulations themselves are fine. Another issue is the independence of ELITA. This at the time was a major issue for the EU. The EU test, whether it's good or not, I'm not commenting on that, but this is their test, is issues of budget. Is the DPA, the Data Protection Agency, is it independent from a financial point of view? Well, the Israeli ELITA is part of the Ministry of Justice and as such is not independent. However, Israel has managed miraculously, I would say, to convince the EU that the DPA is independent. Well, it is to some extent.
Land of miracles.
Well, yeah, it is. and its status, the head of Elita's status, is equivalent to other gatekeepers, such as the Commissioner of Antitrust. Do you remember what happened to the previous Commissioner of Antitrust? He's no longer in his job, etc. So, and these are backward-looking issues about the previous adequacy. When I'm looking forward to the GDPR and ask, okay, we have a check on data breach notification. We've done that now and done so very nicely, and the Ministry of Justice should be commended for that. It's a nice job. But what about CPOs, Chief Privacy Officers? What about privacy by design? So you mentioned, Rory, a couple of privacy by design examples, but I would also mention another one that you have omitted inadvertently probably, and that is in the what's known as the biometric database law. There's a CPO there too, but oh my God, about privacy and that law, okay? And there is no general duty for CPO in Israeli law. Privacy impact assessment, right to be forgotten. Many things that are in the GDPR, and there's not even a sign of a bill in Israeli law. So sorry to break the party, but there's some tough issues here. So I'd appreciate comments. Bruno, would you like to start?
The first reassuring thing is that as an Italian, I'm feeling very well because you speak even longer and more than I do. I should come here and be settled here. So anyway, it's not about being overly optimistic. We are not optimistic, we are responsible. And a very important point here to stress is the level of scrutiny. 10 years ago, even 5 years ago, those issues were technical issues that would have interested half of this room. Now, we might like it or not, but we have paid the consequence of that. On adequacy decision and more general privacy issues are seen as societal, political issues in Europe and here too, which are subject to very high scrutiny by our courts and by our stakeholders, data protection authorities, European Parliament, etc. And we have, as I said, with the annulment of the safe harbor, we have seen a tangible demonstration of that level of scrutiny, and that's why we are working with our adequate partners to make sure that the adequacy decision in place can continue and are sustainable. So that's, nobody is here ignoring the complexity. The Article 29 Working Party, which is the body that gathers together the DPAs, the data protection authorities in Europe, has already signaled to an opinion last November, I don't remember, that they have certain questions on existing adequacy decisions, not only the Israeli ones, but etc. I must say, to be very frank, that the issues of national security access or public authority access are particularly sensitive issues and complex issues, and that Israel, together with other adequate countries, Canada, New Zealand, because of a certain closeness, for all good reason, of relationship with the US, is looked at for this issue. So nobody here is but I also said that adequacy is you did the checklist. Adequacy is not about that point-to-point, as I said, symmetry or duplication. I think also to answer what I hear here from the private sector, nobody has said that there's a one-size-fits-it-all approach to data transfer. On the contrary, the GDPR broadens the toolbox for international transfers, but I still think that we should and we can be ambitious, and it's in our mutual interest with countries which share similar values and principles, like Israel, which have an overarching legislation in the field of privacy, which have enforceable rights, which recognize privacy as a human right / fundamental right, and we have a supervisor with independent powers. Then I understand that this is a matter of discussion, and we will discuss this, I'm sure. And it is with those countries that we should have adequacy and we should continue to have adequacy. As I said, for other situations, and we have now opened up and broadened, we have tools for transfer that really address the variety of the different type of transfer, certification, code of conduct, different use of BCRs or standard contractual clause, etc. But again, I think that Israel is in that club, in that league of relatively limited number of countries. We see also signs of upward convergence. We have intensive adequacy talks with Japan, for instance, that has just opened it just to broaden our horizon. So again, nobody here is overly optimistic or is denying the complexity of the exercise. We simply want this exercise to be successful, if I can put it in a diplomatic but firm way. Thank you. And then I have spoken at least as long as an Israeli, so I can be silent. Yes.
I just comment, just as Bruno said, I didn't think the GDPR is a one-size-fits-all. On the contrary, I said I think it has a pragmatic point of view, that it has alternatives to adequacy, various or expanded alternatives to adequacy, and I think that's a great alternative. I'd leave the discussion that you're aiming for to these two gentlemen.
Thank you. Sure. So thank you for that, Michael. And I do have to say, I mean, I don't think I could say I could respond to this better than Bruno did. We approach it exactly in the similar in the same fashion. You know, we understand that an adequacy determination is something that is ongoing. We think that the conversation with our European colleagues about what we do, about developments here, about developments in Europe is important. And can help, as Bruno said, both parties better understand each other. I think, you know, there is something here in Israel which, you know, I'm always very proud of. You know, we do have a very vibrant academic community and NGO community that is very active in pushing different rights, and you play certainly a very important role in the area of privacy, and I think it's only natural that you know, you will bring to the table the half glass empty, and it's absolutely fine because of people like you. We continue, not just, but you know, you certainly play an important role in pushing many of these issues forward, and we are very grateful for that. You know, but obviously, you know, one way is to look at the half glass full, and another is half glass empty, and another is to look at the half glass full. If I compare where we are today compared to where we were in 2011 in terms of privacy protection in Israel, you can see significant and important changes and improvements, and that's before we put on the table what is currently within the pipeline. I will also say that, you know, the GDPR is an innovative and important legislation. It gave a grace period of 2 years to, and you know, generally for people in private sector, 2 years, you know, is a long time. For governments, you know, sometimes it takes longer. And so, you know, as we're studying the GDPR and considering some of the changes we may want to introduce, and we may do some of that, you know, also the dialogue here is also helpful in designing what we want to do. You know, we don't see this 2 year as necessarily, okay, here at this point we're looking at this. And the last point, again, I agree with Bruno completely. This is not an exercise about checklists. And as Bruno said, at the core of this, there are two countries or entities in this case that do basically share similar values and similar commitments, do face similar challenges, especially when we speak today about national security and we speak with our counterparts in Europe. Some of the questions, including the ones that Commissioner raised here this morning, are questions that we deal with them also. And so I think this is a very good basis for a discussion and conversation. And Bruno said he doesn't take an optimistic or pessimistic approach. He takes a professional approach to it. We're very happy to take a professional approach to this and see where it gets us in the end. I allow myself to be at least hopeful that we will end with maintaining the adequacy status, because I think at the end of the day it basically reflects the similarity in values, and it also serves both the interests of the EU and Israel to actually maintain this status. So at least I approach this with an optimistic, with an optimistic intention at the very least. Thank you.
Thank you. We have a few minutes for Q&As from the audience. Professor Tenne, please.
Thanks, Michael, and thanks for this great discussion. So, Lloyd, you talked about the pipeline. One of the things that have been in the pipeline for a long time now is a legislative bill which was government-sponsored and actually passed the first call in the Knesset to enhance the enforcement powers of my friend to the right here, the Israeli privacy regulator. We talked about enforcement powers on the GDPR session earlier and how incredibly impactful just that change could be. So my question is, when, if any time, do you see that development actually materialize?
Okay, so again, thank you for the question, and I will take the opportunity also to say something in addition about ILITA. I'm very hopeful that in the very, very near future we will be able to announce the promotion of this legislation. I don't, as I'm sitting here, I think, we are in kind of final political, or taking what the political steps necessary to ensure that, and hopefully very soon we can announce it. And I agree with you, this is a very significant piece of legislation, and if we can pass it through Parliament, I think this will be fantastic. I just, I feel I don't want to take the thunder of making these kind of announcements before, this is fully agreed among the relevant political stakeholders. But let's say it this way, I'm very optimistic with respect to this legislation. I agree with you, it is important. I do want to say that, if we look at ILITA today, even compared to where we were in 2011, we see significant developments, right? We see the courts in important court rulings actually expanding the powers of ILITA, recognizing or giving support to them. We see increase in both in budget and in manpower, and we see the significant role that ILITA plays in every single thing that happens today in Israel that involves issues of privacy. Every major or every major and not so major legislation is accompanied by the expertise from ILITA. So, at the very least, I would say we're in a better place in this respect as well.
Thank you. Some more questions from the audience. Yeah, please.
I would be curious, Bruno, if you say how this is done in Europe, and you can then maybe say something about Israel.
He's a good politician.
Well, when I was talking about one of the pillar of a system, which I think is a pillar of the system here too, is that in privacy, precisely because it's a fundamental or human right, you need to have, contrary to other models in the world, an overarching legislation which applies, it can be to one law or several laws, but applies exactly the same principles, obligation and right to any processing of data, independently of what is the sector or of activity, etc. Of course, there are possibility to derogate and to modulate certain of these obligations in light of certain requirements of public interest, etc. But that's captured by our system because it's captured through, for instance, the variety we have in terms of basis for collecting data, the way rights are exercised, including, for instance, the context of direct marketing, which is typically, but they cannot be a carve-out or derogation, a full derogation for one economic sector. Processing of data is processing of data and raises issues of protection human rights regardless of the sector of activity. And in the sectors you've mentioned, indeed, some of the sectors are, could be particularly data intensive and therefore data intrusive, if I may say.
Yes. And I will just say I completely agree. I don't think that there is any suggestion that these sectors are somehow exempt from privacy laws in Israel. Sometimes with some sectors we actually do think that there should be enhanced regulation of a particular sector. In these cases, by the way, not just for privacy reasons, some of these sectors, because of the risks they create, not just to privacy, but you know, the fraudulent risks. So yeah, no, so right, so the government, as you know, is taking steps with respect to these sectors. As we do that, I'm sure we also take a look at privacy implications. So you have, at least as a baseline, you have your privacy laws, and then you create concrete arrangements in places where risks are higher. So that's just as a basic approach.
Our time is over, so ladies and gentlemen, please join me in thanking our panelists.